May it please the court. My name is Marlene Otero and I represent the prosecution. Your Honor, today's argument is focused on whether a consented search of the defendant's computer is valid under the Fourth Amendment. Your Honor, would you like to hear a quick rendition of the facts?
Yes, please.
Okay. The case at hand involves appropriately seized evidence from the defendant's computer. The defendant, Mr. Tory Fisher, an eccentric playwright, was discovered missing by his niece and nephew on July 10, 2012. This was unusual for Ashley and Jared, the niece and nephew, due to the fact that they had a trip planned to the Rock and Roll Hall of Fame. Furthermore, the cell phone and wallet were left at the house. After doing a search around the neighborhood and making a few phone calls, an effort to locate their uncle to no avail, Ashley and Jared decided to call Strongsville Police Department for help. The police arrived and did their usual questioning for missing persons, primarily focused on the mood and demeanor of their uncle the night before. This was because Mr. Fisher had period bouts of depression that they feared that they had ran off to commit suicide. In an effort to gather more information, the detectives asked Ashley and Jared if they could remove Mr. Fisher's computer for further review of their uncle's whereabouts by an IT professional. The two gladly consented. After missing for 24 hours...
Excuse me, Counselor, what did they think a computer was going to tell them, the computer was going to tell them about his whereabouts?
Right. Basically, they were looking for any sort of clues that might lead to foul play or general unhappiness, that might lead to, if maybe he had run off to commit suicide. He was known for having bouts of depression, so they're hoping that maybe a search of terms could help locate him.
I see.
So after missing for 24 hours, Mr. Fisher was located 5 miles away from the home with no recollection of how he had got there. A day after Fisher was found, he called Strongsville Police Department to request the return of his computer. Police officers compiled with the request and informed Ms. Dolores Umbert, the IT technician, to terminate the search. She did as instructed. However, when Ms. Umbert went to retrieve the computer, she discovered that the lawful consensual search had yielded an image on the computer that was unmistakably child pornography.
When did that image come onto the screen?
We don't have a direct timestamp of when it came onto the screen. However, she went immediately to the computer to terminate the search after she had received the email that he wanted the computer returned to him.
And it was right there?
And it was right there on the screen.
Okay.
Given the plain view of this image, she further decided to investigate and found 10 additional images of child pornography. Mr. Fisher has since been arrested and charged with the possession of child pornography. The prosecution's argument, Your Honor, is that the Honorable Court should grant our motion to admit that images of child pornography seized by the defendant's on the defendant's computer because the evidence was obtained within the appropriate scope of consent. Furthermore, even if the court finds that the seizure obtained was not within the scope of consent, the seized evidence falls within the plain view exception to the warrant requirement.
But that was a thumbnail, was it not?
Yes, it was a thumbnail. However, Ms. Dolores, which was the IT professional, stated, and I quote, that she had seen the picture appeared what to be a nude underage male cowering on the floor beneath an older naked male wearing a black hood.
She saw that from the thumbnail?
Yes. To us, Your Honor, this is not an image someone makes up in their head. This was a clear description of what she saw in the thumbnail, and it gave her probable cause to further investigate after the plain view of the incriminating evidence.
How is it that that's in plain view?
As soon as she walked up to the computer, the thumbnail was right there, directly in front of her, and she was able to see the image of the child pornography.
All right, here's my concern. I have a computer at home that does exactly what it pleases, but I assume other people's computers don't do the same thing. How did that thumbnail get up there?
She had run the search terms specifically to find his whereabouts. I don't know exactly what terms she used. She is an IT professional, though, and she did run terms in order to specifically find his whereabouts. And it turned out later that the image thumbnail was called Punishment. She may have ran a search that to see if maybe he was thinking of doing anything to harm himself. So the image was yielded from the search that she looked in order, which was within the scope of consent. So my first argument is that first and foremost, the evidence was within the scope, and it was found while it was legal consent of the search of Mr. Fisher's computer. Mr. Fisher's niece and nephew consented in hopes of finding their uncle. U.S. v. Matlock, a Supreme Court case, has held that the Fourth Amendment recognizes a valid warrantless entry and search of premises when the police obtain the voluntary consent of an occupant who shares or is reasonably believed to share authority over the common area of the accused.
How is it these two teenagers shared authority over the common area of the accused?
They actually would stay with him every summer. I think 3 consecutive summers in a row they stayed with him, and they would live with him. He would watch over them for the summer. So under U.S. v. Matlock, we believe that they did have.
Is there anything in the record that indicates that they were actually using that computer?
No, Your Honor. So furthermore, additionally to this, the standard of measuring the scope of consent is that of objective reasonableness. That is what a typical reasonable person would understand he or she was consenting to, given the information sought by the police. This was held in Florida v. Jimeno. Here, it is reasonably understood that Ashley and Jared understood that the IT technician would run the search on Mr. Fisher's computer in an effort to locate him. The IT technician, Ms. Delora Umbert, did in fact only do the search terms that might be associated with foul play or general unhappiness that would lead to Mr. Fisher's whereabouts. These terms were within the scope of consent and yielded the illegal image that appeared on the screen during the consensual search. As a result, evidence was obtained through legal consent and should be admissible into evidence. Furthermore, even if the court were to find that the Strongsville Police Department exceeded the scope of evidence to the search, the seizing of the child pornography images is still legal under the plain view exception. In Horton v. California, the Supreme Court held that in order for a seizure to be admissible under the plain view doctrine, the incriminating evidence of the character of the object must be immediately apparent, and the officer must not violate the Fourth Amendment in arriving at the place where he or she sees the evidence. Here, Mrs. Umbert walked into the room with the purpose of stopping the search as instructed and was immediately confronted by the images of illegal child pornography.
No, it would just be just as easy to get a warrant after she saw this particular thumbnail, just to verify what it was and then to go forward in the search.
Correct, but we feel that the consent was never withdrawn, so therefore she had, when she went to the computer to withdraw, to stop, just to return the computer, the image was in plain view already within her view, therefore we believe she had probable cause to further investigate. With that, and that would be the exception to the plain view, not needing to obtain a warrant.
Because the computer was in the possession of the police at the time that this thumbnail came up on the screen, how do we know that in fact those images were the defendant's images?
It was run through his computer. Initially, anything that appeared in the computer was from anything that he had searched, any search terms that he had. We don't have direct or anything in the facts that leads us to believe that anyone else used the computer, but due to, especially the public policy argument, that it could affect, first off, well, our public policy argument is that the court should take into consideration something like child pornography on one's computer because they need to protect the physical and psychological well-being of a child.
So you're suggesting we should create an exception to the warrant requirement when there's child pornography?
What we believe is that in cases such as this, we believe it was in plain view, first off. Our argument is that it was in plain view and that she had probable cause to further investigate. When it comes to child pornography, we do believe, especially since U.S. v. Long Supreme Court case has held, that the way that evidence is found, usually with a child pornographer or someone that watches or views child pornography, is only the way it was discovered on the computer is the only way it could realistically have been discovered. Child pornographers like to, hide, maybe keep things away from the public, and not allowing the government to prosecute when this has come into evidence we feel would be against public policy.
I'm still baffled because in reading Jimenez, I see that it says that the search is defined by its objective.
Yes.
And its objective was to find someone. Not to find pornography, but to find a person. And once that person was found, doesn't that consent then stop?
Right. Well, our belief was that when she went to the computer as someone who worked for the police department, she was automatically confronted with this image.
Well, I would think the computer wouldn't be on and that she wouldn't have left it on.
It was running a search, and when she approached the computer, the image was there for her to see.
Okay.
Your Honor, may I just finish my
Mhm.
conclusion? Okay, accordingly, Your Honor, we ask that this court grant government's motion to admit evidence found by Mrs. Umbert while legally searching Mr. Fisher's computer. Thank you, Your Honor.
Thank you.
Thank you.